Let's begin our discussions this morning, and it has to do with our next guest. The Nigerian Labour Act is the primary legislation which deals with the relationship between an employer and his employees. It contains quite a number of provisions which govern this relationship dynamic, as well as all the regulatory processes applicable for employers. Now, here in our Lagos studio to give us insights on the provisions and highlights we should all know about in these times when employers have begun sending staff on compulsory leave during this pandemic, and many fear loss of jobs, and many are truly losing their jobs already. Ms. Kashimana Tsumba, good to have you on the show this morning. Let's begin with that very, very, vital question as to how an employee can actually protect his job, in these times of COVID-19. And what are the legal, provisions actually for that?
Good morning. Thank you very much for this opportunity. So the employer and the employee are governed by the Nigerian Labour Act. Most importantly, I'll start by saying that the Labour Act makes a distinction between different kinds of workers. There are some people who refer to under the Act as workers and some non-workers. The Labour Act really covers those that do manual labour, those that do clerical work. So most of the protections afforded by that Act cover that set of people. Those who are categorized as non-workers under the Labour Act are actually covered by their contracts of employment. So at this time, it's more important than ever for those who don't fall under the category of non-workers to have good contracts, employment contracts, because really those employment contracts are the documents that are going to determine what their rights are at this time.
And if, as an employee, you are concerned about the threats of going to work or the dangers of going to work, can your employer actually make you come to work?
Well, your employer can make you come to work. However, you are entitled to days off under the Act. You are entitled to sick days. And also, in light of what is happening now, we know that there is a restriction of movement. So unless you are involved in essential services, there are government regulations now to the effect that people shouldn't move around except those involved in essential services. So at this time, your employer can't make you come to work. Even under normal circumstances, if you have a cogent reason why you can't come to work, like you're ill or there's something wrong with you, with your family, no employer can make you come to work, because that's an infringement of your fundamental rights.
So, Kashimana, let's look at that in a bit more detail with regards to the infringement of one's fundamental rights, because that is something that happens quite regularly across the world. Now, looking at this situation that's currently taking place globally, the COVID-19 pandemic, it's unprecedented. Nobody, if we're looking at 2019, nobody ever thought we'd be in this position by April 2020, but we are currently in this position. What happens to an employee whose employer states, regardless of what's taking place, you must be at work, regardless of who is considered an essential worker under the Constitution, if you will, you must still appear at work? What does that employee then do?
So that's a really delicate question, because then you have the issue of what we call in law the doctrine of undue influence, because an employee and an employer are really not in reality on the same footing. So the bargaining position will always tilt. Well, not always, but will typically tilt in favor of the employer. In a situation like that, what I would advise is that the employee, if the employee seeks to pursue its legal rights, then it's important that the employee puts it in writing that they cannot come to work and state the reasons why they can't come to work. Or there should be some documentation about why they can't come, because really it's illegal to go to work now if you are not part of the essential services. There's been a regulation put out both by the Lagos state government and by the federal government that movement is restricted. So it's all now a question of Are you ready to stand up to your employer and tell them, this is the reason why I can't? And I would advise that employees do that, because really the real risk is the risk of an arrest. If you are found going to work when there's a legal restriction on you going to work that is backed by a regulation, then it's a criminal offense.
Now, a number of employees actually do have insurance in the event of things like this. But, I mean, a pandemic outbreak hardly has happened in this generation. None has happened, unless you're talking about the one of 1917. And for many employers, they're losing a lot of money. And what have you. Now, what are the protections that I have as an employee in a time like this, not to even make it more difficult for the employer who is losing quite a lot in terms of, funds and what have you?
So for the non-workers that are covered by the Labour Act, it's important to look at the provisions of the Act, finding out what the protections are. I understand that in this time, lots of employers are losing money. So typically, people will want to cut their losses. But it's very important, even for those not covered by the Labour Act, that are only governed by their employment contracts, that companies make sure at this time that they take steps that are not in breach of their contracts with their employees. Now, the Labour Act does not allow an employer to force compulsory leave on the employee. Section 18 of the Act speaks to the issue of leave. Leave happens by agreement between the employer and the employee. Yes, there's a provision there saying that by mutual agreement, leave can be deferred. But even that has a cap of 24 months. You cannot defer it before that. And remember, the important word there is by mutual agreement. It's not something that should be unilaterally done by the employer. However, we cannot run away from the reality of the situation wherein even when the employer tries to coerce the employee into taking their leave, the employee really can't fight back, because there's that real fear of losing their jobs. And I really had a lot of people contact me saying, they've been forced to go on compulsory leave, and they've also been, in some companies, they've even offered to pay them the leave allowance. But really, it depends on what is in your contract, and the law doesn't allow you to do that. Now, I've had arguments from both sides of the divide. I've heard people say, look, if they're giving their leave allowance, then there's nothing wrong with that. That's like saying, if I meet someone, sorry, this is an extreme example, but saying, if I have a relationship with a girl and I were to rape her, if I pay for it, then it doesn't really matter. It does matter, because consent is important, and the agreement must be mutual. So in a situation like this, what I would advise companies to do will be to, one, for those that have contracts, work within the parameters of the contract. Engage employees. It's difficult for everyone. When you engage employees, you can have supplemental agreements. But rather than force them to go on leave, the law doesn't allow you to do that.
And I'm wondering, the Labour Act, if it's not almost obsolete in the light of this latest developments, would you, as a lawyer, based on what you know about the Labour Act right now, and I would actually like you to talk to us about the key, some of the key points in the Labour Act, and do you think some of those actually would need to be reformed post COVID-19 in a way that will reflect the changing times?
I'll say that the Labour Act needs a lot of work to be done. I mean, it protects quite a number of rights, but the law must keep progressing as times change. So there are issues in the Labour Act there are some issues that are not dealt with in the Labour Act, but the Labour Act allows, and also we need to remember our legal system. What happens is there's the law, but there's also the interpretation of the law that is done by the courts. So the written law is quite different from the interpretation of the law, which forms judicial precedent. And what happens, judicial precedent is the position that the courts take on an issue. If the court has written a judgment and the most superior court, like the Supreme Court, takes a position on an issue, then that is the extant law as it stands. So the law now, right now as it stands, the employer can actually terminate the employee's employment. And that can be done on a services no longer required basis. So your employer can come to you and give you a termination and say services no longer required. However, he must do it in line with the contract. He must follow the stipulated notice period in the contract. If you are governed by the labor law, there are stipulated notice periods there in the labor law saying how much notice your employer should give you. So that is covered. But I think that Nigeria can even go further, because now international best practices say that, the employer should state why your employment is being terminated. And we've seen that at the National Industrial Court, where the court is now beginning to lean towards international best practices, where there are times when the court will inquire into the reason for termination. I would advise also, because there needs to be a balance, because there are two interests here, both the employer and the employee. Employers should err on the side of caution. I've seen all kinds of write-ups coming from different companies, banks, established companies that you would not expect. I've seen where people have approached me where their companies have filled leave forms for them and told them to just sign 28 days of leave, compulsory. And some of these companies are putting this in writing. HR managers and in-house legal counsel need to be very, very careful about things like this, because these are actionable matters. The correspondence that goes between them and the employee is very important, because those things can be used in evidence against these companies. Yes, we're trying to manage costs, but also avoiding litigation, avoiding being sued is also a part of managing costs. What costs have you managed if at the end of the day you have a class action, you have a group of your employees taking you to the National Industrial Court? So I would advise employer-employee engagement at a time like this. Sitting down, a sit-down forum where you can discuss the challenges of the business and redefine what your contract is by mutual agreement.
Okay, well, Kashimana, it is time for us to take a quick break on the morning show, but we will be rejoining you after the break to discuss further the legalities and the implications of COVID-19 in Lagos and Nigeria. Stay with us. Welcome back to the morning show here on Arise News. We are still joined by legal practitioner Kashimana Tsumba, who has joined us to discuss the legalities and legal implications for both employers and employees during these times of COVID-19 and the global pandemic that we find ourselves in. Now, my question to you, Kashimana, is the right to freedom of movement. A lot of people have said that this lockdown, if you will, and in some countries, in some parts of the region, curfew even, has curtailed their rights to freedom of movement. But my question now is, must there always be an enabling law or piece of legislature that will trigger the response of the government in circumstances such as these to let people know when they can and cannot move around? And is that legal, if you will?
Okay, I've heard the arguments about freedom of movement and people's constitutional rights. But what we need to understand as a people is that there are different constitutional rights. There's a right to life and there's a right to movement. And your right to movement stops where your neighbor's right to life begins. And we all know that this is a contagious disease. So we cannot exercise our right to movement in a vacuum. It's important that we see those rights contextually, really, really important. Beyond that, our constitutional rights are qualified rights. We may not know that, but if you look at the Constitution, it is a qualified right, and the government has the right to make regulations for the public good that will limit some of those constitutional rights. So it's not like there are blanket provisions. On the question of whether regulations are necessary, yes, regulations must be made. We can't just have directives. There must be regulations. And that's the whole idea behind the principle of the separation of powers, the executive, the legislature, and things like that. Laws must be made so that people know what is the yardstick, what am I allowed to do, and what am I not allowed to do, which is why the federal government and the state government have made regulations with regard to movement in respect of COVID-19.
Talking about how it affects COVID-19. Now let's even look at health workers in Nigeria. a lot of them are the ones who are actually in the front line of the war against COVID-19. And you've had, situations where nurses and even doctors before COVID-19 have been, going on protests, striking and asking government to provide the basic necessities for them to be able to do their jobs. And now, alas, we have COVID-19. And a lot of nurses have been complaining that they don't even have the PPE, the personal protective equipment that is needed, a very, very basic requirement if they can or they are to fight COVID-19, in order to protect themselves and not to get infected. When the employer does not provide these basic requirements, how should an employee who is a nurse or a doctor or a health worker, how should they, seek for justice in order for them not to go against their Hippocratic oath?
So what happens is that there are regulations that govern such issues. There's a public health law which gives the Commissioner of Health the rights or the power to make regulations in respect of the health system, in respect of healthcare providers in situations like this. So the Commissioner actually has the power to make regulations that will govern and protect members of the healthcare sector. While I do appreciate that, they are facing a challenge, that's an issue that can only be dealt with legislatively. The Commissioner will need to, and Lagos State has actually been quite proactive, and they've actually really done a lot. They've been a step ahead. In fact, the regulations that were made here were made before the federal government began to make regulations, which I really applaud them for. But you know that we are in unprecedented times. These are things that this is something that hasn't happened before on a world scale. So sometimes I do understand that response time may be slow, and I do really sympathize with the healthcare professionals, but that really comes within the power of the Commissioner of Health, who is actually their colleague. And I think that they can have groups that can write and lobby in this respect so that these issues are dealt with.
With regards, let's just take that a step further, the point that Ngozi made with regards to these essential workers in the healthcare space. Now, as you mentioned, they have undertaken a Hippocratic oath to do their duty no matter what. But with regards to other essential workers during this crisis, during these times, if you look at countries like America, people that stock the shelves or, warehouse stockers in Amazon, for example, a lot of these people have contracted the virus and have had to leave their jobs. And so these huge companies, these multinationals, are now, the baseline pay is so much in order to attract people to come and work for them during these times. So my question to you is, what are the rules on, or the laws rather, on hazard pay for these essential workers during this time? Because as we know, people in the healthcare space don't have the luxury of hazard pay. They've undertaken this Hippocratic oath. But a lot of other people who are considered essential workers have not undertaken this Hippocratic oath. So are there any laws that pertain to hazard pay within the Nigerian constitution, furthermore within employee-employer contractualization in Lagos?
I would say again that the government has a responsibility and has the power to make new laws. Because, the regulations that have been made in respect of infectious diseases and emergency prevention have been made only recently in the last month. So the government actually has the apparatus, the necessary strength that it requires to make new laws to cover these hazardous activities that are affecting our healthcare practitioners. But these are things that have not happened, and the response time is seeming to be slow because this is the first time this kind of thing has happened. Do I think that should happen? Yes, I think that should happen. And like I say, through their professional bodies, they can lobby the government to do these things because it's very important. Lives are being lost every day, really.
Let's even look at the legal angle of this, what one might call wole in Lagos, where the Lagos state government has come out with a policy of sending pairs to actually go to homes, from house to house to check for COVID-19 patients. What are the legal implications of that, if any?
Sorry, I didn't quite get that.
About Lagos State's new policy, which they are considering, we don't know if they've really come out fully with that, to send people out in twos to check, from house to house for COVID-19 patients. And I'm wondering if there's any legal implication to that.
Well, I'm aware of the helplines, but I'm not aware that Lagos State is sending people in twos to homes to check. And the regulations that Lagos State has issued on the infectious diseases have no clause or no section saying that people will go from house to house. I know that the governor has the right to order that people be taken in for testing or for screening where he feels that there has been some exposure to the virus, but I'm not aware that people can go in twos to people's homes. I haven't seen that in the law.
It's not yet a law,
no,
but the Lagos State government is planning, or rather the Health Commissioner has planned.
My point.
And you know what's interesting to note is also the fact that we've had the Quarantine Act of 1926 that used to protect British sailors from yellow fever and Lassa fever and all the infectious diseases in Africa. So I wonder if it's time for an update of that Quarantine Act.
Oh yes, people have been calling for that already, that it's quite obsolete. Kashimana Tsumba, a lawyer, thank you so much for joining us on the morning show today.